And joining us now to deep dive into this case is attorney Mark Trammell. He's the CEO of the Center for American Liberty. Mark, thank you so much for joining us. First, what did you make of the oral arguments today and where the high court seems to be leaning?
Yeah, that's a great question. I think it looks like the states are going to prevail. I think it's always dangerous to guess the tea leaves of the Supreme Court. They can certainly surprise us. They've surprised us in the past. But it does look like states are going to prevail or likely to prevail on this issue. Title IX was created to open doors for women in athletics specifically, not to close them. And I think what we saw consistently through the line of questioning from Justice Alito and several other of the justices was just pointing out some of the inconsistencies in the arguments presented by namely the ACLU, an inability to even define what it is to be a male or a female or to define sex. And when you have a law that is designed to prevent discrimination on the basis of sex, it's imperative that the court can, at a minimum, define that term.
I want to expand on that because that does seem to be a big part, or at least it was making a lot of rounds on social media. Talk to us about that. How unusual is it for a case to be argued without a definition for a critical term central to the case?
Well, I think this is what the court is designed to do. It's designed to interpret the law, right? It's designed to interpret language within statutes, and that's what it's being asked to do today, to define what Title IX means when it prohibits discrimination on the basis of sex. I think there's a very common sense understanding as to what this means. I think some on the perhaps more politically left side have struggled. I think even we saw today at the court, the attorney for the ACLU struggled to be able to define sex and to be able to define what it means to be a woman or a female. And that's going to be very problematic. I think that's very problematic in oral argument today. And I think ultimately that's why I think the court is largely going to rule in favor of the states. Now, having said that, I don't know that what we're going to see out of the court is going to be just a home run for the states. Right? There's a question, there's a way that the court can rule in a very narrow fashion. And the court loves to do this, right? The court loves to rule narrowly in perhaps the least disruptive manner. The court is specifically asked whether conservative states like Idaho, like West Virginia, may provide a restriction, may segregate athletics on the basis of sex. And the court can come down on that question and say, yes, they may. Now, that's a different question being presented to the court as to whether states like California are required to then, under equal protection and under Title IX, require athletics in high schools and in colleges to be segregated on the basis of sex. That question, we'll see what happens. We'll see if the court goes that far. I'll be surprised if the court goes that far. I think ultimately, at the end of the day, the court is going to say that, yes, states like Idaho, like West Virginia, may restrict on this basis, and that is perfectly consistent with Title IX. It's perfectly consistent with the Equal Protection Clause, but we'll see how the court comes down on this one.
I want to dig into that because the states say that their current laws don't violate the 14th Amendment or Title IX. Unpack for us the 14th Amendment's Equal Protection Clause. How is that playing out in this case?
Yeah, so you can't discriminate on the basis of sex and other immutable characteristics under equal protection, right? You can't discriminate on the basis of race or nation of origin or alienage. In fact, these are highly codified protections under the law. Now, what is consistent with these protections is that they're immutable characteristics. And that's why we have these laws in place. When sex can be something other than immutable, when it can be fluid, the protection makes zero sense. In fact, what it actually does is an application here is it takes opportunities that were fought for legislatively and that are afforded to women, and it gives them to young men. And so that clearly is contrary to the intent of Title IX. It's contrary to, I think, years and years of case law of equal protection. The whole idea here is that there's an immutable characteristic, immutable meaning it cannot change. You cannot change your sex. I think of Center for American Liberty. We represent Chloe Cole in her lawsuit against Kaiser and the doctors who tried to transition her really brutal medical procedures that she underwent, double mastectomy as a young child. And I think she actually gave an interview today where she said, look, these things were done to me. They didn't change who I was. They didn't change my sex. They just injured me. And, I think here the same truth is applicable. You can't change your sex. It is immutable. And that's why we have equal protection on this basis. But there was a lot of discussion today at the court as to whether transgender identification is the same as on the basis of sex. Again, that's going to be a question that we'll have to wait and see how the court rules.
A lot to watch for here for sure. Mark Trammell, thank you so much for joining us.
Thanks for having me.